Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the Self-insurers in Australia podcast. My name is Alorna Strong. I'm a partner at Hall & Wilcox and oversee our national self-insurance practice, and I'm delighted to be the host of our new podcast for self-insurers. In this series, we'll be discussing topics that are relevant to your day-to-day claims management as a self-insurer and give you an insight into how claims may be managed in various jurisdictions across Australia. So sit back and relax, or keep pumping those legs if you are exercising, while we take you through our first topic, which focuses on whether an injury has in fact arisen out of or in the course of employment. I'm delighted to be joined today by Olivia Raymond, a Senior Associate in our Statutory Insurance team in New South Wales. Olivia has many years of experience acting for self-insurers in New South Wales. Welcome, Olivia.
Hi, Lorna. Thanks for having me this morning.
So today, Olivia, I'm going to go through two scenarios. Olivia, scenario one. Emma, a warehouse supervisor, has just finished her shift and was eager to get home. As she was about to leave the warehouse, she realised she had forgotten her personal phone charger at her workstation. Wanting to grab it quickly before heading out, she hurried back to her workstation. On the way, she slipped on a patch of spilled oil near one of the loading docks and fell, spraining her ankle. Emma was taking a shortcut when she fell over through the loading docks. She did not follow the usual pathway when leaving and arriving to work, as she was in a rush and really wanted to get home. Now, Olivia, do you think Emma's injury arose out of or in the course of her employment?
Now, in New South Wales, the Workers' Compensation Act for injury provides in Section 4 that it must be a personal injury arising out of or in the course of employment. So in this scenario, there's looking at the bigger picture, there's less of a difference in workers' compensation between completing your shift for the purposes of pay and when the course of your employment ceases for the purposes of sustaining an injury. Now, in this case, granted the worker's shift is finished for the purposes of her pay, they haven't left the premises where her employment occurs. Her journey hasn't started because she hasn't crossed the boundary. She's remained within the warehouse, and therefore it's likely to fall within the course of employment. Now, in terms of the worker taking a shortcut and not following the usual pathway, whether this is a compensable injury will depend on whether that conduct amounts to serious or willful misconduct. Now, the Workers' Compensation Act in New South Wales does provide that where it can be proven the injury was solely attributable to a serious and willful misconduct of the worker, it won't be compensable. As in this circumstance, on the face of it, it seems unlikely that the sole cause of the injury was as a result of that action, having there been a spill and so forth that made her fall. But in saying that, we would still recommend reviewing the workplace policies and procedures regarding the reasons why they're instructed to walk a particular way, to see if that would cross that serious and willful threshold.
Okay, so if she was actually walking back to the office to collect her work laptop, would that make a difference? But it sounds like from what you're saying, the injury would be compensable regardless of whether or not she was walking back to her workstation to collect a personal item as opposed to going back to her workstation to collect a work item.
Yeah, particularly in New South Wales, if this matter was to go to the Personal Injury Commission, it's likely that a member would regard what the worker was going back for as irrelevant. The fact that they remained within the premises of where they performed work, they would disregard whether it was a personal phone or a work phone that she was going back for, charger. So it's likely that the injury would still be compensable. And in saying that, also if she fell walking the designated way as well.
Yeah, okay. So if she had actually left the warehouse, gotten in her car, driven away, and then perhaps driven back, would you then say that would not be compensable?
That would have a stronger argument, yes. Assumably she's crossed the boundary because she's got in her car and driven away, then her journey has begun. So she's actually left that boundary line and stopped the course of employment. So that has a much better chance of being defended in the New South Wales Injury Commission.
Yeah, okay, that's really interesting. In terms of if you were a self-insurer and you had this claim and you were perhaps trying to defend it or working out whether or not liability should be accepted or not, or denied or rejected, whatever the appropriate terminology is, what evidence would assist in this matter if you thought you would want to defend it or try to defend it?
So in terms of if we got to negligence in this matter, the protocol of where the workers are instructed to walk will be really important to defend it on the basis of contributory negligence. Any evidence of the policies and procedures regarding the safety of the workers to walk a specific way would really be of assistance in this one.
Yeah, so there's probably only really a negligence defence in this one, because from a statutory benefits perspective, from what I'm hearing you say, Olivia, is that realistically you would have to accept this claim because she hadn't left the boundary when she was injured. So it would be considered to have arisen out of her in the course of her employment. But there may be an opportunity down the track, should the worker pursue a damages claim, to raise some issues around negligence and contributory negligence on the basis of what the protocols potentially had to say in that, what the policies and the procedures were that were given to workers in and around accessing their workstations and leaving the warehouse.
Yeah, that's correct. Yeah.
All right, excellent. Thanks, Olivia. I might jump into scenario 2 now and take you through that, and we'll go through some questions. So Adam was employed as a security guard with Secure Corp on a part-time basis. Now, depending on the number of shifts he was allocated, he could work between 10 to 20 hours per week. On 28 May 2023, he was rostered to work as a security guard at the Melbourne Cricket Ground, the MCG, which hopefully you're aware of what that is, because that is Melbourne-based.
I am.
Great. So perhaps a similar ground in New South Wales. I'm not sure what one would be. The Sydney Cricket Ground.
Yeah.
So let's say it's the SCG. The plaintiff received an email from his employer, Secure Corp, regarding the gates that were open and should be accessed for him to attend work. So Adam was driven to work by a co-worker who parked his car park in the car park outside of, we'll say, the SCG, and entered through gate 7. Whilst walking through the car park to the SCG to commence his shift, Adam slipped and injured his left leg. So Adam completed a claim for compensation about 2 weeks later, alleging that he had slipped and injured his left leg and knee in the SCG car park near gate 7 and on the 28th of May 2023. Adam also alleged a psychological condition. So taking this scenario into account, Olivia, do you think that this injury arose out of or in the course of Adam's employment?
So this one turns on the fact of where the boundary is, where the worker is working. So his shift hasn't started yet, and the car park is outside the SCG, where we would consider that the boundary begins. The Workers' Compensation Act provides that an injury received by a worker on any journey is deemed to be an injury arising out of or in the course of employment. But as the worker in this matter hasn't began his shift, he's parked his car in a car park which isn't owned by SCG, then in New South Wales, would be arguable that he hasn't sustained the injury within the course of his employment.
Okay, so interesting that you mention about the ownership of that car park. So what would you say, Olivia, in this scenario, if Adam was directed to park in a car park that was owned and operated by the SCG, would that make a difference in terms of whether or not you'd consider this claim to be compensable?
That would make a difference, yes. Yep. If the worker was directed to park in the car park, and if that was owned and operated by his employer, then there's likely to be a real and substantial connection between his employment and the accident, and is more likely to succeed in the personal injury commission.
Okay, so in terms of then trying to defend that matter in the personal injury commission, the evidence that you'd want to gather, what would be some of the things that you would really want to be stressing to the commission in terms of the scenario where it wasn't owned and operated? So the original scenario.
Yeah, in the original scenario, you would look at the time get evidence of the time that he was starting his shift, the instruction that was provided to him. In that scenario, he was instructed to enter through gate 7. Presumably he's parked at a car park near there, but until he gets to the stadium and goes through gate 7, and had he slipped then, more likely to be in the course of employment. But in terms of evidence regarding that instruction to go through that gate, obtain that evidence, also obtain evidence that's not owned and by the employer. And in terms of the second scenario of whether that was owned and operated, or if it wasn't owned and operated, but at least there was a direction to park there, then what caused the worker to slip may actually be important as well. If he had slipped on an uneven surface on the footpath of the car park, then it's more arguable that there's no real and substantial connection between the worker's employment and the uneven surface of the footpath. So getting those statements from the worker at first instance to get all of the facts. I believe he was driven to work by a co-worker, so a statement from the co-worker, and any CCTV footage of the incident occurring that would assist in defending the matter. It would go towards any work and do damages as well, but it would also help for the commission.
Okay, so in summary, you'd look at the emails or the directions that were given to the worker, get some statements from the worker himself and the co-worker, and also look to see whether or not there was any CCTV footage that should assist. That would probably be really the gamut of the type of evidence that you would be wanting to gather and have in your arsenal if you're going to defend this matter before the commission.
Yeah, that'd be right.
Excellent. Thanks, Olivia, so much for your time. That was fabulous. I just want to also thanks everyone for listening today. In next week's episode, we'll be getting a Victorian perspective on these same scenarios. So it'll be really interesting to see how Victoria deals with a similar situation. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you've enjoyed today's episode, then rate, review, or follow our podcast wherever you get your podcast. Thank you and goodbye.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.